It's a case of love turned deadly. But the details in this story are so much worse because of what the killer did next. Not only did he kill the girl he said he loved and her dog, but then he made a chilling FaceTime call. And you will not believe who is on the other end witnessing what he had just done. We're on The Case, presented by Law&Crime. I'm Chris Stewart. Rarely does taking a life ever make sense, no matter the reason, no matter the excuse. But in the case we're talking about today out of Arizona, where a man shot and killed his girlfriend and her dog, what he did after is chilling. This is Hannah Rogers. She was 30 years old. Her family says she was a beautiful, smart, and funny woman who lit up the room with her smile. You can see that personality in this picture. This was at her sister's wedding in 2023, and this is a picture of her with her date to that wedding. His name, Taton Dorfman. People called him Tate. She made this her profile picture on November 29th, 2023. The top comment on that picture was from her boyfriend, who said, "I love this picture, my beautiful love of mine." Hannah Rogers responded saying, "Thank you for loving me, baby." He said, quote, "You don't need to thank me, baby. You are worth loving." Now, before I get into what happened in July of next year, let's talk a little bit about this loving boyfriend. This is still his profile picture today with Hannah Rogers. We also know that Tate is a dad. He has several pictures with kids and he has a big smile on his face. And when you look at this, it makes what happened inside the home he shared with Rogers outside Tucson, Arizona, even more confusing. The date, July 28th, 2024. It was around 10:30 that night that police were called to the couple's home on West Mosquito Drive. You can see it's a walled-off community with townhomes. Now, the reason they knew something was wrong at this house, it's awful and it's shocking, along with what they found inside. Hannah Rogers, with a gunshot wound to her head, the fun-loving, caring girlfriend, had her life stolen from her. And not only was she dead, her dog was also killed. The person who fired the shots was none other than the man who less than a year earlier told Rogers that she was worth loving, which she responded by saying, "I'm so damn lucky." What happened after the shots were fired is anything but remorse. Dorfman made a call on FaceTime, and that call was to his ex-girlfriend. According to K-Gun TV, when he made that FaceTime call, Dorfman was laying next to Rogers, the girl he had just killed. There was blood around her head. Not only was he boasting to his former lover about what he just did to his current girlfriend, he also reportedly said, quote, "I killed her, I did it." The ex-girlfriend screenshotted that call. She contacted police and they responded to the home. Now, when they arrived, they needed a SWAT team to take Dorfman into custody. He barricaded himself inside the house for several hours, but then he surrendered to face the criminal justice system. He had blood on his face, blood on his hands, and they also found a handgun. He also allegedly told police he did it. Now, it's not clear why Dorfman did what he did. Police say they found a large amount of drug paraphernalia in the home and a lot of alcohol. Now, here's an image of Dorfman at a court hearing per KOLD TV. The 30-year-old went on trial for second-degree murder and a misdemeanor animal cruelty charge for killing the dog. On September 4th, Dorfman was found guilty on those charges, and this week he was sentenced. A court in Pima County, Arizona ruled he will spend 16 years in prison. Now, if that sounds light for this crime, here's why. According to KOLD TV, in court, prosecutors told the judge that they regret not including aggravating factors in this case. And the judge said because those were not included, the maximum that Dorfman could be sentenced to was 16 years. Dorfman also got time served for that animal cruelty charge. Dorfman's defense reportedly asked for 10 years in prison so he could provide for his children. In court, convicted of murdering his girlfriend and calling his ex to gloat about it on FaceTime, the local TV station says that Dorfman addressed the court and said this, quote, "I'm not a killer, I am not a murderer." Now, no one knows how they would react unless they were in a situation like this. If this happened to one of your family members. But Rogers' family is not taking an approach that many of us might think we would take if we were in their shoes. Rogers' sister-in-law says that she forgave Dorfman for what he did. She said that he made a mistake and that her sister would not have wanted her family to live with the weight of not being able to forgive her killer. There is a GoFundMe right now for Hannah that has raised more than $11,000. As for her killer, he will get out of prison if he serves his full sentence in his mid-40s. I typed Taton Dorfman's name into truthfinder.com, and in the criminal records section, we see that he has been in contact with the justice system for more than a decade, including in 2014 when he was arrested for drug possession. At Law&Crime, we partner with Truthfinder, and we use it to get details on the people involved in our stories. But even if you don't work in true crime, it can be a great resource to give you some peace of mind because it's one of the largest public record search services in the United States. And with the paid subscription service, you get access to unlimited reports about almost anyone. And right now, you can get 50% off your first month of confidential background reports. Just go to truthfinder.com/OTC. Join us now to talk about this case is Joe Tamburino, criminal defense attorney. Always great to have you on Law and Crime. I will admit with this case, we're only getting so much from inside the courtroom about how this trial went out. They didn't allow cameras in the courtroom for it, but I found it interesting. There was the line in the news report that prosecutors even admitted at sentencing that they should have added aggravating factors. And having a prosecutor admit that they made a mistake, I think is something you don't often see. But what would be those aggravating factors in this case that they could have put in?
Almost all states, and thanks for having me on, Chris, have what's called aggravating factors. And they're pretty much the same. In Arizona, it's things like using a deadly weapon, causing great bodily harm or death, which we know has happened here. But more specifically, it's about, did you commit the crime in a heinous way, in some type of cruel way? And I would imagine that applies in Mr. Dorfman's case, because not only did he simply shoot Ms. Rogers in the head, but then he, for no reason, shot the dog. And then after that, he bragged about it to his ex-girlfriend, who wound up calling the police, obviously. So, you know, I think aggravating factors would have applied. And I think it's good that the prosecutor is saying, look, you know, they made a mistake. They should have done that.
When someone, you know, in terms of, for those of us on the outside, when you say you're going to add an aggravating factor or fact, like what is the process of actually doing that in a case to make sure that that's on the record, that you believe these different factors, like how much, I guess what I'm trying to ask is how much work would it have been to actually do that in a murder case?
Not much, because ever since 2004, under the U.S. Supreme Court case Blakely v. Washington, what the Supreme Court said is, look, if you're going to, you the prosecutor, the state, if you're going to add additional time to a defendant's sentence, time that otherwise they wouldn't get under your state law, state statute, you have to prove those factors beyond a reasonable doubt. So not only do you have to prove that the person's guilty beyond a reasonable doubt, but also these aggravating factors, whatever they are, particular cruelty, heinous acts, whatever they may be. However, that's really not much extra work because you're already going to a jury trial to prosecute this person. So all you have to do is prove a few more, perhaps even just one more element to the crime to the jury. Now, the jury here had no problem finding Mr. Dorfman guilty. I would imagine if they also had the decision as to whether or not, beyond a reasonable doubt, he used some type of cruelty or heinous acts, they likely would have found that too.
One thing that just stood out to me before we get to the other parts of it, I mean, he admitted that he did it. He calls his ex-girlfriend. She, and good for her, FaceTiming and screenshotting everything that was playing out, and then she calls the police. There was a line in the release that there were drugs found in the house, drug paraphernalia, and a large amount of alcohol. If he was impaired, could that factor in at all to making this a second-degree case of maybe he had a bad, I'm just, kind of spitballing here, but like, let's just say he was on some sort of drug and the drug made him hallucinate and he did this and then he calls his ex-girlfriend. Is that a defense in a case like this?
No, not in of itself. It could be a partial defense of what's called specific intent. For instance, there are things called affirmative defenses. The biggest one, the most popular one, is self-defense. So you as a defendant can say, I'm going to put the government on notice that I'm raising the defense of self-defense, meaning I agree that the victim was injured, but I did it in self-defense. And then you have what's called, you have to put up at least some type of evidence to show that. The same thing with alcohol or drugs, but that is, in most states, used for specific intent crimes. So you could try to say that my voluntary intoxication affected my ability to specifically intend to cause death, okay? But that has to be what's called pled out, meaning you have to give notice of that to the court and to the prosecutor. I don't believe that was done in this case, because if it were done, we would have known that through some type of jury verdict, instructions, and so on.
This seems very minor, not saying that dogs aren't important, like I want to be clear saying that, but he only got a misdemeanor for an animal cruelty charge related to shooting and killing an animal. Is that in line typically when someone does something like that, as opposed to there being a more serious charge?
Yes, it is. It's usually in line with that. The only type of animal cruelty charges that I have seen that get to felony levels is if you you intentionally kill an animal who is of a certain character or type. Let me give you an example. You kill a police dog. Yes, sometimes that could be in certain states a felony. You kill a helper dog, like say the victim is blind and it's using a seeing eye dog, something like that. But normally just killing a dog, a cat, whatever that is, that's a misdemeanor.
And it's 16 years he's going to get, and that was the maximum the judge had said without the aggravating factors added to it. So, I mean, he shoots and kills somebody, shoots that person in the head, shoots their dog. I know that the aggravating factors weren't brought in, but he's going to be out in his mid-40s, which seems like a really good deal for him considering what he did. For that to be the max based on no aggravating factors, a second-degree murder, and I know it goes from state to state. I mean, how does that compare to other states with how much time he could have received for what he did?
It's a little on the low end. Most states will have for a second degree, meaning it's intentional murder, but not premeditated. And the person has, assuming no prior felonies, that is. Usually those fall in about the 20 to 25 year range. However, we don't know the gradations of second degree in Arizona. Like, in many states, you could have a second degree, which is quite lower because it's what's called a felony murder, a murder that happens in the course of a felony, some separate felony. Those are usually going to be lower than, say, intentional second degree murder. So you'd really have to get into the nitty gritty as to what this particular second degree was about.
And then his defense tried to, their proposal was give him 10 years in prison. He is a dad. He has multiple kids from what we see. And if he gets these 10 years, that allows him to get out when he would be 40-ish, and then he can provide for his kids. How far does that argument typically go in violent crimes like this one?
Almost nowhere. That argument usually has traction, and, many cases rightfully so, in drug cases, in property crimes, in financial crimes, sure. But when someone is seriously injured or dead or raped, no, that argument really doesn't hold any water, because basically what you're saying to the judge is, look, he's a family man, he has kids, so you should really let him out in 10 years for this murder. Well, that makes no sense, because anybody who's a family man, has kids, wants to provide for their kids, wouldn't shoot somebody in the head.
And then he in court reportedly said, I'm not a killer, I'm not a murderer. I mean, he is. He was found guilty of second-degree murder. And I know this was the max for what he could get just based on what he was convicted of and all the circumstances surrounding this case. But when it comes to an impact statement like that in court, where you have a suspect who is not admitting guilt, he's not saying sorry, he is just saying, I'm not a killer, I'm not a murderer. What type of impact can that have on that day in that courtroom on a judge's decision?
A negative impact for the defendant. Think of it this way. You're facing 16 years, and your defense attorney is arguing for 10 years. So that means the judge has to give you 6 years less in order to agree with your defense attorney. So what would you normally do in a situation like that? Normally, usually, you would say, I'm extremely sorry. I did do this. I'm guilty. I don't know why I did this. We went through a trial, and I realized that, yes, I did all of this, and I'm extremely sorry. I don't know how to make up for it, and so on. You give the judge at least something so that maybe there's a shot at getting less time. However, if you've been found by a jury to be guilty, meaning that the jury found that you in fact did intentionally kill this person, to walk in front of the judge and then say, I'm not a killer, which is basically I didn't do it, after a jury just found that you did do it, no, that's not going to have any weight to the judge. It's going to work against you.
I've been in court for, verdicts in my career, and obviously you have as well, and bond hearings. And I always find it interesting where you'll hear, these impact statements, which can be really emotional. And in some cases, these hearings can go for hours. And then it comes up to this moment where a judge, it feels like 30 seconds, where they're looking over their papers. And after the hours and hours of testimony, in some cases, the judge then just says, I find, in a bond hearing, whether you're granted bond or not, or in a case like this, I'm going to give you 16 years in prison. How does a judge come to that conclusion? Are they already walking in, already having made their decision on what's going to happen? I just always find it interesting over that period of time, just how quickly they can come to that decision after, in some cases, very emotional and long testimony when it comes to impact statements.
I think, and I've been doing this 36 years, and I couldn't even tell you how many, tens of thousands of times I've been in court, that judges, for the most part, know how they're going to sentence someone before they get in that courtroom. Yes, they will take into consideration what's said in the courtroom. Look how long P. Diddy's sentencing hearing lasted. That was only a few weeks ago. But for the most part, judges have a pretty good idea how they're going to sentence the person, which is why, from a defense perspective, you want to get your information, your arguments, your legal memorandum, your letters of support, your psychological evaluations, all of this information to the judge weeks ahead of time, weeks before sentencing. Why? Because when that judge, a few weeks, maybe a month before sentencing, is going over in his or her mind how they're going to sentence your client, you want to make sure that your materials is in front of them. That's where they're going to have the most impactful part of the whole process, rather than simply waiting to sentencing day and making an argument in court. It's a greater impact if you get this information to the judge early on.
And then in the case of Hannah Rogers' family, I can't imagine what they're going through, and I can't imagine what I would do if I was ever in their situation or how I would feel. It's certainly easy to sit back and say I'd never forgive somebody who did what Dorfman did to Rogers and her dog inside of that house. But to their credit, they, in court, her sister-in-law, said that she forgives Dorfman, took the approach that that's a weight off of her. He still got the max, but in those cases where you see a victim's family give forgiveness, what type of impact have you seen that have on the sentencing for someone who's found guilty of a terrible crime?
In murder cases, in death cases, not much of an impact in the sentencing. In other cases, such as burglaries, assaults, robberies, things like that. Sure. If you have a victim who comes in and says, yes, this person robbed me on the street, but, I have forgiven him. I understand his personal and maybe financial background. I don't think it was absolutely the right thing to do. However, I have, gone beyond this. I think something in those areas will have an impact. But when you get into a death case, even if the victim's family, even if they find grace in forgiving, the defendant, I think the judge is happy for the victim's family that they have found peace. You always want the victim and the victim's family to find peace somewhere in this process. However, in death cases, will it really have an impact on the judge? Not much.
And then you read this story for the first time, and it's just, and I'm sure, in all your years of being a criminal defense attorney, not much shocks you anymore, but the idea that he would go on FaceTime like this, call his ex-girlfriend, boast about it. Just what was your reaction when you first read this story and you saw what Dorfman did in the house that night?
Unfortunately, I wasn't that surprised, and here's why. It seems in society, at least over the last 5 to 10 years, people cannot help themselves on social media, on texting, on Instagramming, whatever it is. I have run across so many cases where a prosecutor will easily go through social media and find pictures of your client holding a gun, making gang poses, holding a gun next to a pile of cash, or holding a couple of guns next to some material that looks like it's drugs. And it's on social media, or it's texting someone, or it's on some other type of venue. I don't seriously know why people do that, but it's quite common.
It's got to be a moment as a criminal defense attorney when you're kind of doing your own research on a client and then you see the gun and drugs picture. That's got to be a tough day.
It's devastating sometimes because you might have a case where you have a client who's been convicted of a felony, say years ago, and they're not allowed to have a handgun or any type of gun. And now they're charged with possession of a weapon by a felon. But you have a good case. Maybe you have a good argument, maybe you have a search and whatever it may be. But then all of a sudden the prosecutor finds on social media with a brief investigation that your client is pictured with that same gun, doing different things with his friends, whatever it is. Yes, that information is devastating. But Chris, I don't know why in society today this happens so often, but it's common.
Yeah, and I mean, on the side of covering these cases, I mean, you see it all the time, that there's stories like this that happen. This one just so incredibly sad when you think of a woman's life cut short by someone who will be in jail. And I know often we're like, oh, 16 years, that's not that much. I mean, you think of just how long 16 years is. You know, he'll be off the streets for a good period of time. Joe Tamburino, criminal defense attorney. It's always great to have you on Law and Crime. Thanks for talking about this story with me.
Thanks for having me on, Chris.
That will do it for On the Case, presented by Law and Crime. Subscribe to us on YouTube and Spotify. I'm Chris Stewart. We'll see you next time.